We are honored to welcome Mr. Bevan,
Yes.
a distinguished legal and regulatory professional with over 24 years of experience in competition policy, corporate law, international trade, and project management. He currently serves as the Executive Director of the Fair Trading Commission of Trinidad and Tobago, where he leads efforts to promote fair and transparent markets. Mr. Trinidad holds multiple advanced degrees, including from the London School of Economics, the University of Arizona, and Harvard University, and is a certified project management professional. He is also an associate of the Chartered Institute of Arbitrators and a certified mediator with a strong background in commercial dispute resolution and international negotiation. We cordially invite Mr. Bevan to share his insights on ADR in Trinidad and Tobago and contribute to today's discussion.
Yeah.
Over to you, sir.
Yes, Soundarya, thanks for the brief introduction about Mr. Bevan. A humble request to Mr. Bevan. Mr. Bevan, you have been complimented with another 10 more minutes for your presentation so that in addition to what you have prepared or going to share, you can also talk about the perspective from the end users, depending upon your practical experience, not only in the Caribbean islands, but also you can just explore where you are right now. I think you are in Peru. And being the Latin American market as a large, as well as the Caribbean, which the connect, that also you can just share so that it will be very interesting for the participants and co-panelists.
Okay, well, I'll try my best for this additional thing you wanted me to do. So no problem. So would I be able to move the screen, or would you be doing that? The slides. All right, okay. So well, okay, I will just say when to move the slides then. Okay. So thank you very much for the opportunity to speak today. It's 11:20 in Peru. As I had indicated to the organizers, I'm at a conference in Peru. I did a presentation at 5:30 this afternoon, and the presentation was actually on advocacy and the work that I have been doing every day in that respect. And I think this is very good as a good segue into what I have to speak to today. And I really appreciate the extra time, because persons who know me always say I need extra time to speak about different issues. And yeah, and I'll give different perspectives, practical perspectives from my experience. So, well, the focus would be initially on Trinidad, Tobago, and CARICOM to give participants a better understanding of where we are at. And I must say, I was listening to some of the previous presenters, and I think we are at a good stage. And I want to thank the Kovise for giving me the opportunity to speak to you all and to share my experiences. So next slide, please. So just to indicate, this is usual that because, as you all would know, I wear a lot of hats. I do a lot of stuff. And that's just to indicate that this presentation is mine and my alone, and the views expressed are mine and not necessarily those of the organizations that I represent. But to just reiterate, these views I think are very relevant to the purposes of this meeting. Next slide. Next slide, please. So just to give persons a perspective, and I think this is very important because we have to speak about this. Trinidad and Tobago is part of the Caribbean community. Now, we're very small. I heard my colleague from Indonesia just speak, and he spoke about Indonesia, China, and India. We are much smaller than you all in terms of population. By the end of the day, we are 15 member states in the Caribbean community region, with our systems mainly being English-based, common law-based, because most of us were former British colonies. And we have relied on, but we are now trying to develop our own arbitration infrastructure now, because we recognize the use of ADR and its effectiveness and its flexibility. And I think that is what we need to always stress. And because of that, our laws are now being amended to suit. And because we recognize, and that's very important because what the host had indicated just now was that the practical perspectives is that we want to encourage ADR. We want to encourage really investment in this region, right? We have certain advantages, we believe, in terms of the fact that we have a very educated workforce in Trinidad and Tobago and in the overall CARICOM. We have very good, I think, a very good geographic location. Collectively we are located close to both South America and North America. But in order to attract that investment, it is very important that we have appropriate infrastructure, an appropriate legal structure, and we believe a proper structure to settle disputes, whether it be through the courts or whether it be through ADR mechanisms, is essential. And we believe that once we have that, it gives investors the assurance that their investments can be protected. And that is one of the things that we are aiming for in the region. Next slide, please. So just to indicate the treaty that formed the Caribbean Community was the revised Treaty of Chaguaramas. And even then, it was very important that they have systems in place for dispute settlement that not necessarily involves the courts. So even from then, we have various ways in which member states of the region, the 15 countries that make up the Caribbean Community, settle their disputes. And as you can see, they go through good offices, they go through mediation, consultations, conciliation, arbitration, and only adjudication at the last level. So countries do not want to reach that level. When their member state disputes, in other words, we don't even want to be like how, for those who know about the European Union, when there are disputes between countries, sometimes it goes before the European Court of Justice. Now, we have a Caribbean Court of Justice, but the idea is for that dispute to only go there. If a member state, for instance, has a trade dispute with another member state, we're only going that level to that court only if we have to. We are looking at all other ways to solve the disputes as quickly and as peacefully as possible. So that is even embedded in the treaty that established the Caribbean Community. Next slide, please. So Trinidad and Tobago, now just to indicate that we have a population of less than 1.5 million. That's where I live. But as I said, we consider ourselves to be very attractive for investment. We get a lot of investment from China, from India as well too, from the United States, as well as the European Union, mainly the United Kingdom. We have a relatively stable legal system. We have a very good geographic location, very educated workforce. We also have energy in Trinidad and Tobago, meaning we have natural gas as well as oil. So this has made energy costs very low, and this helps that we have a structure that could assist with that. And just to also indicate, we also are part of the various diasporas. As I went in my pre-meeting, I had indicated I am fifth generation Indian and proud of it as well too, with origins from Kolkata, but as well, I also have origins in Hong Kong as well too. And that also has a reflection in terms of the investments that we can get in the region. In terms of our and Trinidad and Tobago, there's also been a proactive approach to infrastructure development and economic diversification. There are the various industries and sectors that the government has targeted for there to be greater investment. Major industries other than oil is tourism as well. Mainly in the case of Trinidad and Tobago has a lot of very picturesque beaches and things like that. We also have a very vibrant manufacturing sector where a lot of products are exported mainly throughout the Caribbean region. But we are also trying to access new markets, and we also have a good financial structure and a financial system where we have an international finance center where entities do come to look at possible investment opportunities. But as with all regions, we have some issues as well too. Red tape has been identified as a major issue. The ease of doing business index, the the World Bank ease of doing business. We tend to not score too high at that at times because of the red tape and bureaucracy that is involved in getting approvals and getting things done. We also have some foreign exchange problems as well too at times, and there are some security concerns. But we think that at Trinidad and Tobago, at least, we as a people think we can overcome these challenges and become even more attractive for investment. Next slide, please. So in terms of international arbitration agreements, well, most CARICOM countries, including Trinidad and Tobago, we are a part of the New York Convention for the enforcement of judgments, and this has been reflected in the work that we are doing. Some states haven't ratified, and efforts are being made to improve that level as well too. Most of the arbitration laws that we have are outdated, we know based on old legislation. However, a growing number of CARICOM states now have recognized the importance of having modern arbitration legislation. And this is mainly based on three countries, notably Barbados, Jamaica, and Trinidad and Tobago, very recent. We have amended our legislation, and our legislation has been based on or greatly influenced by the ancestral model law and arbitration. I must say as well, I have a very good knowledge of that model law because of the work I did when I worked in the Caribbean community. I did actually work there prior to this present appointment, and so have a very good understanding of the model law. And we try to encourage other states in the region to adopt that law in terms of getting amending the legislation to make sure that they were in accordance with that, because we recognize how old and archaic the present arbitration laws are. So we are trying now to encourage more of that, and hopefully that could happen soon. Trinidad and Tobago, that was a major effort on the part of the Trinidad and Tobago government in 2023 to have new arbitration legislation that would be based on a modern system, such as the ancestral arbitration law. So next slide, please. So just specifically with Trinidad and Tobago, we are have been party to the New York Convention since 1966. We're also a party to the long-standing to the ICSID Convention. We, in fact, some of the work that that I did that was with respect to disputes that would have been settled through ICSID as well too, where some investor state arbitral rewards were enforceable in the jurisdiction, and we are a long-standing member. As I said, the new legislation was that is in line with the ancestral model law, because at the end of the day, we recognize the need to foster a conducive environment for international trade and investment. I was previously a member of the board of directors for the Trinidad and Tobago Trade and Investment Promotion Agency, and when we reached out to investors, they would have spoken to us about the need for a predictable regime, and this included a good regime for alternative dispute resolution, and which we took that into account and encouraged the government to have that legislation in line with the ancestral model law. And right now, the courts have recognized the need and the importance of ADR, and now they are expressly required to stay court proceedings in favor of arbitration where a valid, and I must say valid, a valid arbitration agreement exists, unless the agreement is null and void, inoperative, or incapable of being performed. And I will mention in a later slide some relevant cases on that issue. So basically, this new law is expected to improve the trade and investment climate, and that has it's very early still. It's only 2023 the legislation was enacted, but the idea is to improve the ease of doing business, and it emphasizes the need, and I think that is very important with ADR, the efficiency and flexibility that ADR and in particular arbitration offers. So we recognize the need for a reliable and predictable environment for investors who are looking for efficiency and cost effectiveness. And it also, of course, strengthens the finality of awards that are made by arbitration as well too. And again, the confidence of actual and potential investors are key, because they need to recognize and know that their dispute potential or otherwise could be settled through a modern, efficient, and internationally recognized arbitration procedure. So we think that this new law can bring that about. Next slide, please. And in doing so, what I would like to also emphasize is that Trinidad and Tobago is not only looking at the fact that we have this law, we also are looking at the fact that that Trinidad and Tobago, because of our educated workforce, we have very well-trained judges. And we have very good institutional systems in place. We also look at ourselves as being a seat for arbitration. You know, you always hear about London as a seat and some other jurisdictions. Trinidad and Tobago is not, at least for the region, so other countries close in this region may think otherwise, but we are looking at Trinidad and Tobago as a place where we can become a seat of arbitration, for at least for the CARICOM region. And we have various structures, institutional structures, some of which I have received training from. I received training from the Dispute Resolution Center. When I was being introduced, I'm a certified mediator, and that was through efforts, training from the Dispute Resolution Center, because they have this arbitration mediation service plus training as well too. The Law Association of Trinidad and Tobago also offers that kind of service as well as private ADR firms. So ADR has been existing in Trinidad and Tobago for a considerable amount of time, and now with the new law, we believe that, that this could also help enhance the work of our local ADR experts, with Trinidad and Tobago becoming a seat for arbitration in the region. Next slide, please. So in terms of how arbitration is used in Trinidad and Tobago, and a more practical element is that arbitration is used particularly for large contracts, because we understand how these things are negotiated, and the need to have these disputes settled as soon as possible. As I said, oil and gas is a big sector in Trinidad and Tobago. Well, anytime you are doing contracts in that sector, there's always an arbitration clause. There's also in construction. Construction is a big industry as well in terms of fixing, building highways and other major roadworks as well too, as well as major building infrastructure. So these often include arbitration clauses, because the need for flexibility and efficiency to get these things settled, because when these disputes arise, and they do just, that such is the vagaries of life. And when these disputes happen, they often take a while to settle if they have to go through the courts. The court system has a lot of cases right now. So that's why arbitration is so important, right? And many that are adopted use the various ICC, LCI rules, and sometimes hearings are in Trinidad or sometimes elsewhere. The local judiciary also recognizes the importance of in a case from 2015, and which also emphasized the need for clear legislative guidance. And going forward, it's expected that our local judges, because we have civil proceeding rules that also emphasize that, to follow a pro-arbitration mandate, limiting court interference and facilitating speedy enforcement of awards. So that has been what we're trying to do. Next slide, please. So we also have a Caribbean Court of Justice. I mentioned the European Court of Justice in passing, and this is the final court of appeal for four CARICOM member states: Barbados, Belize, Dominica, and Guyana, but not Trinidad and Tobago. Trinidad and Tobago still goes to the Privy Council in the United Kingdom for our final appeals. But in terms of the CCJ has also been encouraging the use of arbitration for disputes among member states. And this is recognized because they also recognize that we need a robust arbitration regime to improve the ease of doing business in Trinidad and Tobago. So, and in the region as a whole. So arbitration is being recognized, the ADR is being recognized at all levels in Trinidad, in the region, and in Trinidad and Tobago as well too. So that's why I think what we're doing today is very insightful, and it really speaks to what is going on all over the world, even in countries that you may not be looking at immediately. Next slide, please. So moving forward, the culture of arbitration is in fact growing in Trinidad and Tobago. Businesses and lawyers are increasingly becoming aware of that. In fact, arbitration has also been a major part of the various trade agreements we have been doing as well too. Trinidad and Tobago has a number agreements. I would have been negotiating earlier in my career bilateral investment treaties with a number of countries, and we also have free trade agreements where there are clauses to settle disputes mainly through the arbitration route, the mediation route, conciliation route, as opposed to going to courts. And we believe that we have a number of arbitrators here, very well experienced, who can assist with that. And we want to leverage our stable legal system and our trained legal fraternity, as well as this new law, to market ourselves as a arbitration-friendly jurisdiction. Next slide. So in terms of other CARICOM jurisdictions, I just would mention that, as I said, other countries in the region may not think like us, in that both Jamaica and Barbados, they're also they have set up systems. Jamaica has the Jamaica International Arbitration Center. A friend of mine was the one who launched that. And Barbados has also been doing some initiatives with that, because both of them are also, and they share some of the similarities with Trinidad and Tobago in terms of having very well-trained legal staff, a well-trained legal fraternity. So everyone is looking at ways in which they can be a seat for potential arbitration matters as well too. Guyana and St. Lucia, two other countries in the region, they are considering setting up arbitration centers. And there's been a general investment in this ADR in the region, and the importance of training the legal fraternity, because this alternative way of settling disputes and the flexibility that it does bring with it and the effectiveness are being recognized. And this will hopefully encourage more businesses to choose arbitration as a way to ensure that the process is fair, efficient, and enforceable globally. Next slide. So in terms of cases, what I would mention in these cases is that generally courts have been enforcing foreign awards under the New York Convention throughout the region. But what these cases would have indicated, particularly, was that arbitration clauses, arbitration decisions are not always enforced. And that's a little unfortunate, but I'd just like to highlight that some of these cases involve the government, and where the courts have made the decision not to enforce certain arbitral awards on public policy grounds. That was why in CB Holdings and Belize Bank versus the government of Belize, the agreement was not enforced because it was felt that it would have conflicted with the Belizean constitution. Then there was a case that has been in the public scrutiny a lot in Trinidad and Tobago, the National Infrastructure Development Company Limited case against OAS. OAS is a Brazilian company where they did some road work, and there was an arbitration award for the government canceling a contract with OAS, and OAS brought the action for wrongful termination of the contract. And the High Court felt that, and the award was considerable. We're talking about over $100 million US. And the court set aside that award. But it distinguished, although it recognized the finality of arbitration judgments or decisions, it was felt that the court was not acting as an appeal court here, but as in its supervisory jurisdiction. So that is where the distinction the court chose, and it felt that it is supervisory jurisdiction and not as an appellate court. It ruled that it was against public policy to enforce that case. So the judgment by the arbitrator in that case. So that speaks to what is going on in the region. I think it's something that we need to, because the OS has appealed, the case is now before the Court of Appeal, and it might go to the Privy Council. And it does speak to the fact that sometimes the finality of arbitration awards are not necessarily being enforced by the courts for public policy grounds, and sometimes the court is not acting as an appellate court in any respect, but as a supervisory jurisdiction with certain powers it believes it has. Next slide, please. So there is indeed some challenges. I said this doesn't really mean the Caribbean region, Trinidad and Tobago, but we still need in order to make ourselves more, and that's why associate organizations like Kovise is very good. We still have to continue the training of professionals, and also we have to increase the awareness of the use of ADR, particularly for small and medium enterprises, because it's a way for them to get disputes settled as well too very quickly. There's also a culture of resistance. I think a lot of persons prefer the finality of a court ruling, but they don't understand many times that ADR could give them that same benefit, that same advantage, that same assurance as well too. Also the fact that enforceability and neutrality, there's some concern sometimes that the arbitrator will rule in front of in favor of the more powerful party. We have to at least clear that and make sure that arbitrators are seen at least as being much more judicious in their views, much fairer and impartial. And there's also the fact that the cost of arbitration could be prohibitive for small enterprises. So the idea is to do some work to ensure that that doesn't deter persons from coming to using arbitration. Next slide, please. Next slide. Oh, coming to the end. Next slide. So key takeaways is that we still have to always look at the public policy considerations, but there has been judicial progress, and that would have been quite clear from the other slides that judges are in fact recognizing and supporting arbitration. But at the same time, we have to there is the public policy consideration that sometimes supersedes in their mind that there's also the need for clear legislation. Some other countries in the region need to adopt this model law. At least their laws, the arbitration laws based on that and international best practices. We still have to do some more work to increase awareness as well too, and training has to continue as well too. Next slide. So areas for improvement, and again, we have to do this as a region, and there has to be a thrust for that, updating laws, encouraging more persons to join the jurisdictions to join the New York Convention. Probably a CARICOM model arbitration bill could help with that and to help the updating of the laws to give the guidance. Court procedures for the arbitration needs to be streamlined, more public education and awareness, and more certification and training as well too. As an example for me, as indicated, I'm an associate at the Chartered Institute of Arbitration. Nothing was holding me back from becoming a FCI ARB, but I guess people like me need to be encouraged to go the extra route because we already have the interest in arbitration, so just go the extra route. But I guess it needs to be, I guess it's somewhat a little commercially viable for me, especially given what I do as well too. Next slide. I think coming to the end. Next slide, please. So going forward, I think that Trinidad and Tobago is, and I will leave it at that here, and then I'll add some of my perspectives. Trinidad and Tobago is positioned to be a leading arbitration venue, and that is where the reforms have indicated. We have adopted the ancestral model law, and that has signified a commitment to improving our arbitration system. And again, we need to, as a region though, reinforce the principles of fairness, transparency, and efficiency in dispute resolution, as this inspires greater confidence, reduce commercial risk, and increase support for sustainable growth. Now, just to add for a minute or two with respect to the work that I do. Now, as indicated, I am the executive director of the Fair Trading Commission. We have had disputes, we have had issues with various stakeholders, and when we have these disputes, we also always try to use the ADR method instead of bringing actions to court. We try to, if we see some potential violations, we tell them to stop. We have identified this, to give you a time period to cut this out, or at least have some kind of mediation to ensure that that stops at the beginning and doesn't go further. And so we even use ADR in regular work as well to when there are some disputes. Even if we make certain decisions and entities want to purposely bring us before the court, we use the particularly mediation though to ensure that doesn't happen. Well, I'm in Peru as well too. I'm given an international perspective. One of the things that it's an international competition meeting that I'm at. And a major issue we had discussed in terms of our advocacy work would be to encourage coming to us, more entities to come to the commissions, but to also know that we will be able to try and settle things without necessarily going to court as well to if there are potential disputes. And as a former trade negotiator as well too, this has been very important when we negotiate trade agreements. I have negotiated trade agreements with part of teams that negotiated trade agreements with Nicaragua, with El Salvador, with the United States, with Canada, with the European Union as well too. And a major part of these negotiations has been the dispute settlement clause. In fact, sometimes the dispute settlement clause is what holds back agreements from being signed. And we have always at times emphasized the need for there to be proper ADR systems in place. And both sides have been in favor of that because we know that we don't want our trade disputes to hold back the success, the potential success and market access that you can get from international trade agreements. And we know that we want increased investment, and investors really do not have, I think, much trust in the court systems here. Not because of the decision making, I think, but because of the time. And time is money. And that's why you need to have proper ADR systems in place in order to attract. So all the work you're doing in terms of trade negotiations, in terms of investment negotiations, to get investors, I think the of equal importance is to ensure that they know that whatever disputes they have will be settled in a fair, amicable manner in a as efficient a time as possible. So I think that would be my contribution right now. Next slide, please. I think that would have been the end. And I'm available to answer any questions that any person may have and to try and address them to the best of my ability. So again, thank you very much for the opportunity to speak to you. It's 11:15 Peru, so tonight. Okay, thank you very much.
Yeah.
Yeah.
Thank you, Mr. Bevan. It was a really, really new, an eye-opener, what I can say, for many of the practitioners in Asia to understand the developments of TNT arbitration legislation. In a personal career prospect, when I was just divulging into the Caribbean islands, or the traditionally we call the East Indies, the act, that is the 2023 Arbitration Act of TNT, which is considered to be like a keeping pace with the international development, particularly on the counterparts, the Caribbean, like Bermuda, which is a tax haven, the British Virgin Islands, and Jamaica, as you highlighted about Jamaica Center for International Arbitration, Jamaica International Arbitration Center, whether it is in the 1993 or during 1996 or during 2017. All these development, whether these development had any significant impact on TNT to come with this 2023 amendment. Additionally, to what extent this particular law or the legal reform happened in TNT has taken it forward for parties, not only in domestic front, but in international front, opting TNT to be a effective seat for arbitration. What is your view on these two?
Okay. I think very good questions. The first I would say is that I think we needed sometimes it's the leadership, and our Attorney General in 2023 was a senior counsel who I think was very much involved in private practice in arbitration, and so he would have a lot of the major practitioners in Trinidad and Tobago. They practice throughout the region. They practice in other jurisdictions, and he may have seen now I didn't mention these countries because both Bermuda, U.S. Virgin Islands, they do have their laws are based on the ancestral model law as well too. So they would have preceded Trinidad and Tobago in 2023. And in fact, I think it was a major, I don't know if it was not getting investment, but I think when investors have to tick the boxes, they would realize that, hey, Trinidad and Tobago has not ratified Trinidad and Tobago, even though we may have we that ancestral model law, which is really the modern law on arbitration, we have not done that yet. And Trinidad and Tobago, all this training we are doing, and and I think he would have identified that, and that I think gave it the impetus to go ahead with it, and so that was what the idea was. So he would have been looking at other countries, and I think, but it would have been his leadership as Attorney General, and as a practitioner who would have worked in arbitration, and probably worked in jurisdictions that had already adopted the modern legislation. So he saw the need for Trinidad and Tobago to have that. In terms of your second question, well, the idea is for Trinidad and Tobago to become this seat. There is no big evidence of that yet. But what I would say is that investors who are ticking the boxes would look at the fact that Trinidad and Tobago offers a lot of advantages compared to the rest of the region, at least in my view. Other colleagues mightn't think so, but I think that our location is very convenient for that. We have a very large profession as well too, and we have these structures in place where there have been a lot of training already taking place with in terms of the Dispute Resolution Center as well as the Law Association of Trinidad and Tobago. Now, we haven't developed like that nice name like how Jamaica has the Jamaica Arbitration Center, but I figure these are in the works, and once we get the drive to do it, I think that we will establish formal things like that, even though we believe that the systems that we have could deal effectively with arbitration.
Yeah, so nice, Mr. Bevan, for the clarification and honest views and opinion as a lawyer looking into the why the 2023 Act was brought in, the reason behind, and the other components.
Yes.
One more with subject to you're not disturbing your sleep. Wonderful.
No.
I also happened to understand in one of the case recently opinion what I gave. There was one opt-in, opt-out provisions in the 2023 Act, which eventually distinguishes the domestic and international arbitration by providing different default rules. One such, what I could see, certain provisions relating to ordering or refusing, granting or refusing interim measures or recognitions and enforcement of award only applicable to arbitration with a place of arbitration outside Trinidad and Tobago. I think, if I am not wrong, Section 4 of the 2023 Act. I look into this as a distinction which might potentially lead to difficulties when determining the applicable rules in a specific arbitration. What is your say on this?
Well, you see, that's sometimes, because I saw it too, and I'm glad an expert like you has identified that. But I think that one of the legislation was actually, before it was passed, was sent to UNCITRAL. And UNCITRAL did indicate that the legislation is in line with their thinking, with the law. So it's not it's why I would say it's based on the law, the UNCITRAL model law, but it's not the UNCITRAL model law, because certain modifications have been done with it. And what I would say is that the issue what you identified there, we'll have to see in practice how that operates, because the law is only 2023. I think that the law is not being applied I think that the case I mentioned there, the OS NIPTEC case, NIPCO case, it's very important to hear what the Court of Appeal says about the enforcement of that judgment, because it's quite clear that certain judgments aren't being enforced for public policy considerations and things like that. But even though that case predates this model law, I still think it will guide the court in terms of the practicality of some of the provisions, such as that section 4, and how, in fact, if that could really hinge the proper application of the law. But so I think it's a work in progress, and will need to see a court probably making some ruling or interpretation based on that, because it really could lead to some problems if in fact this interim thing, opt-out thing, if that is something that really could create some practical unworkability. And one of the things I say, what happens with that is when an investor comes in and once the dispute settled, and if they see something like that holding back out, they will in fact raise the issue. And plenty of these investors who we're talking about are large multinationals. Like in the oil and gas sector, it will be BP or Shell or one of these companies as well too. So they will want to ensure, and if they find issues with that, bet your bottom dollar, that's a saying in Trinidad and Tobago, they will bring that to the attention of the various policymakers.
Oh, thank you, Bevan. I hope you'll be a fellow in the coming period in the Chartered Institute of Arbitrators. But overall, what we can understand from this, your wonderful presentation, is that even though the Act is largely adhering to the model of framework, this Act represents a significant milestone in modernizing the arbitration landscape in this, what we, the Global South countries look into Trinidad and Tobago as a twin island state. Hope I am right on the term, what I'm using.
Yes. Yes.
This introduction or the introducing provisions like strengthening judicial respect for the arbitration agreement or the clause, enhancing the role of courts in supporting the arbitrations. It's a very unique phenomenon, because normally we see less court intervention. But here, what we can use is that enhancing the role of courts in supporting arbitration. It's good. And anyway, the streamlining the enforcement of award, the Act which brings TNT. We always think about TNT when it comes to cricket, and a very, very popular destination wherein India was the first country to just break that monopoly of cricket from West Indies after getting the
1983. I remember that very well.
Yeah.
It was in fact a very strange day, because I remember I was 8 years old on that day in June of 1983, and I cried, and my father and grandmother were very happy.
Yeah.
So that speaks to them still being very much part of the diaspora.
Yes.
And in fact, my father's greatest moment, most memorable moment, was in 1970 when he took a train to watch a test match where Sunil Gavaskar had made 2 centuries. So that was in fact one of his childhood heroes. And just another side, my uncle, he's a writer, has written a book about Sunil Gavaskar. And yeah, Clifford Narinesingh. He has written a book, and I met Sunil, well, Mr. Gavaskar, on a few occasions. So he's a family friend. And 1983 was in fact a very great day for my father. It was not a great day for me.
Anyway,
Still love West Indies. I support West Indies throughout. Sorry, even played India.
It's interesting. It's interesting.
Yes.
As a later comment, even sports disputes are now being arbitrated. The Court of
Yes.
Arbitration, Sports, and all the Olympic Association and federations we do have. And anyway, as a add-on, hope I was also on the same age in 1983. 1970 was the first World Cup where the West Indies won. I was just born. I'm now exactly 50 year today, May 23rd, 1975. I was born. A very happy moment. And with this momentum, our relationship should start. And Trinidad and Tobago and the Caribbean community as such, with the institutions other in the Global South, we all have to align ourselves and just make this, whatever the efforts made by the sovereign states when it comes to arbitration laws, we have to make it in line with the best international practice and hope this model law would be structured the way how it was expected. Thank you. Thank you, Mr. Bevan, for spending your valuable time from Peru. Thank you.
Okay, great. Take care. Thank you very much.